Hey everyone, welcome to another episode of 4GQD. We have a very special episode today. With me is my co-host Cerebral Paul, known in the gaming community, also known as Paul. But we have entertainment attorney Joshua Lacine with us. Welcome to the show, Joshua. Glad to have you here.
Hey, thank you, Carlo. Hey, thank you, Paul. Thank you, audience, for having me. It's great to be here.
Yeah, absolutely. I'm excited to get into some of these topics with you because I know that you've seen it from the other side, not just the fan side, but from the corporate side on all this stuff with IPs and Hollywood studios and whatever else we could probably throw in there. You've probably seen it all at this point. It's come across your desk at some point.
I've seen a few things in my days, for sure.
So I'll start off with this. The first thing is, how did you get started into the legal field with entertainment? What was your, because not everybody goes to entertainment law. People sometimes go into different areas of law, like personal injury, but you went to entertainment.
Personal injury, mergers and acquisitions, big law, all of these are much more financially lucrative than entertainment per se. But going back to the idea of fandom versus corporate life and whatnot, I always was a fan growing up as a kid. I knew I wanted to work in Hollywood. I knew I wanted to work with filmmakers directly. I was just, enamored by the filmmaking process. And I remember being a little kid and being more interested in watching the behind the scenes and like the documentaries of how movies got made, like the Star Wars and Lord of the Rings, like the behind the scenes stuff. And it just, I grew up in a small farming community in Iowa, but it really kind of turned me on to this larger world of cinema, art, and filmmaking. And I really, growing up as a kid was kind of a prolific cinephile and made home movies at home with my friends. And so, I knew I always wanted to do something that was tangential or touched Hollywood, that was somehow involved in the film and television making industry. But I was also kind of a weird kid that was into economics and social studies and math and arguing and debate team and those kind of social skills. So I somewhere growing up as a kid, I knew that there had to be some kind of lawyer that was responsible for negotiating the actors and the writers and the producers and the Spider-Man and the IP transitions from this company to the next. And it just always sounded like such a cool and fascinating career. So I moved to Los Angeles in 2011. Went to law school at Pepperdine up in Malibu and have been working, pretty much full time in Hollywood ever since.
Oh, wow. That is a journey coming from a small farm town to the big city, Los Angeles.
Yeah. I didn't know a single person in the state of California when I moved here, but I got the phone number and email address of my aunt's ex-husband's boss's wife's sister's kid.
Oh, wow.
Who was just leaving Summit Entertainment at the time to go work at American Idol. And this was way back in 2010, 2011. Summit Entertainment, for those who don't remember, they were the original producers of the first Twilight movie, and then after the success of Twilight 1, Lionsgate purchased them up. So I spent my first year in law school working at both Lionsgate doing merchandising statements, name, voice, and likeness credit statements as it relates to Bella, Edward, and the third one, I forget their name. Their head sizes and how their credits are displayed on box sets and on DVDs, on merchandise, totes, lip gloss, those kind of things. I spent my first year in law school doing that. I also worked, at American Idol doing music licensing. I worked at Discovery Channel on unscripted content like Ice Road Truckers. And then, for a very brief period of time, I was actually a legal intern at Marvel Studios, which your audience might find interesting. I actually got to work there at probably the coolest time ever because it was 6 to 7 months after Disney had bought them out. And I was part of the process of moving the office physically from Manhattan Beach up to the Disney Burbank lot and got to see firsthand the integration of Marvel into Disney. So that's kind of a cool, interesting time to be there. But yeah, I've done a wide variety of different legal matters across television, film. I'm what is known as a transactional attorney, right? So I just do contracts. I don't wear a suit and tie or go to court and argue in front of a judge, and I don't sue people, but I help TV shows and films supervise the day-to-day business and legal operations, as well as working on behalf of, actors and personalities and TV hosts and writers, directors, producers, and negotiating their deals and making sure that they get the best deal for the projects that they're working on.
Nice. Too
Yeah,
bad you couldn't convince them that, vampires don't sparkle, but,
That's above my pay grade. Above my pay grade.
So when you're doing this kind of stuff, one thing I wanted to ask you about, and I don't know if this has come across your area or not, or maybe it goes to a different part of the legal team, but let's talk about YouTube or videos in general and talk about fair use. One of the biggest questions in our community is it okay to take, let's say, a 10-second TV clip or movie clip and then put that on YouTube and then put your face in front of the clip and talk over it like as if you're either voice acting or you're giving an opinion on it? And, people consider that a lot of times they like, oh, well, that's fair use. But is it always fair use if the channel's monetized? This is a question I have.
So fair use is probably one of the most misunderstood aspects of copyright law. People throw that term out there almost like a blanket of protection when they really don't understand or really know the nuances of the ins and outs of how fair use works. For starters, fair use is an affirmative defense, meaning that you already are basically admitting that you committed some form of copyright infringement, and you're relying on that as a defensive position in order to block a lawsuit. That's already a bad place to be because you've already had to hire lawyers to try to put forth that argument, and lawsuits are already going around, and you're expending time, money, resources, and headache to try to fend it off. But even worse than that, fair use is always decided by what the courts call a case-by-case analysis or by a case-by-case situation, meaning no one instance where the court rules that there's fair use, that isn't a blanket license for everyone to go out and do that exact same thing. The courts will generally look at and weigh 4 factors. One being, what type of use is it? Is it a commercial use or is it a non-commercial use? Is the infringing party making money off of it? In terms of YouTube and Twitch content and reposting, like you said, if they're getting monetization, that's going to be a for-profit use, and that's going to strike against what is considered fair. You're making money off of something else somebody made, not exactly fair. And the second category being what's the nature and use of the underlying material. Is that material for free, or is that something of commercial value? If it's something of commercial value, if you're stealing something of commercial value from something of commercial value and making commercial value, again, not exactly fair use. But if you're taking news clippings that are part of public domain, or they're old, or they're part of just the news zeitgeist, then those could potentially be considered fair. The court will also look at what the monetization harm is your copyright infringement diverting views or clicks away from the original underlying content, because that's going to be a big factor in deciding whether or not it's fair. And then ultimately, the court also takes into consideration notions of traditional free speech and freedom of speech in this country. They have to balance people's copyright interests and people's interest to talk about things that are within the public domain and be able to verbalize and talk about things, freedom of speech. So long-winded way of saying that every single potential infringement of fair use has to be decided on its own particular merits. And I'll give you a really good case in point that maybe your viewers or listeners can kind of use as a guiding post or example. But there is one pretty prominent YouTube fair use infringement case where somebody, and I forget the channel's names, and maybe I'll send them to you after this, but someone was taking full-length videos from someone else's YouTube channel saying that it was commentary but they were really only commenting on one thing here or there, or they were making fun of something here or there. And the guy took them to court, and the court did say that this is not fair use. That commentary and criticism as a blanket is not a, you can't just say I'm criticizing somebody's work, therefore it's fair use. The court actually has to analyze, are you actually criticizing something? There's a prominent Twitch streamer, and I wish I would remember their names. QTC or something like that.
XQC?
Cutie, or do you mean Cutie Pie or Cutie
Not
Pie?
Cutie Pie, XQC, I think is who it is.
Oh, yeah.
He gets a lot of flack that I've heard, because he will take full videos of people's, documentaries, and he will have them streaming in the background, and he will go do laundry, or he will go make himself a sandwich. And that really is straddling the line in terms of what is considered fair use. If someone were to, decide to bring a lawsuit, the court would they have to analyze it on a case-by-case basis. Is what the person doing actually considered fair? Are they actually adding commentary, criticism, newsworthy information about it? This is often a question that I get from new and potential clients coming into my office, because I have a lot of clients that want to start YouTube channels where they're reacting to things like unscripted TV shows and things like that. The best advice that I can give you is to really, minimize the amount of other people's content that you're using and amplify the amount of criticism and screen time that you have. It's a balance, but there is no black and white rule. Anyone who tells you that you can take 3 seconds of this or 10 seconds of that, or, one image of this here and there, they might be right in terms of macro context, but there is not a blanket rule like that governs fair use.
So it'd have to be determined. If a company challenged it, it would have to be determined by a court of law.
Correct.
So if it goes to a court of law, typically with copyright infringement claims, which kind of courts do they go to?
Federal. So usually, if you filed for federal, so copyright protection at common law begins the moment your pen touches paper, the moment your fingers hit keyboard, the moment your paintbrush strokes on a painting. Your copyright protection begins at common law. You don't have federal protection for copyright until you file and register with the Copyright Office. And that just affords you a whole slew of benefits, because you've now gone on the record, you've let the government know that you own this copyright, and it's like you planting your flag in Antarctica. This is mine.
Yeah.
If you just are relying on a common law copyright, there are protections in that, but those protections are limited, and you don't have the presumption of ownership that you would in the same way by filing a federal copyright. Right. So most times, if it's something serious enough where it's actually, stroking the ires of a copyright infringement going to litigation, those usually will be decided by federal courts.
Okay.
I could be mistaken, but I've heard, I'm older than everybody here put together. I know I'm not quite that old, but there was the poor man's copyright, where if you had like a finished script, you would mail it to yourself and leave it closed and have it dated and all that crud.
A lot of old wives' tales go on to a lot of these Hollywood stuff. And so, the idea of that is that, like, back in the day, if you were mailing something to yourself, it would have a stamp of government issuance. There would be some sort of government record in terms of the date in which that you had mailed it to yourself. So therefore, you could kind of, like, it just creates evidence that you can claim that you have common law copyright ownership because it's dated as of this date. It doesn't give you full federal protection.
It doesn't give you full protection, but one of the producers that we interviewed relatively recently, he suggested that people, if they really are stuck, that they can do that as just a fallback position, to show that, I had this script 2 years ago, you're coming out with it now and claiming it's yours, and I can show you that this work was mine 2 years ago.
I think that can be beneficial in certain circumstances, but in the digital age where there's locked copies and there's forensic evidence, and you can get into all of the computers and stuff like that's where it's different. I mean, again, with the typewriter and the date and the pencil and all that stuff, things have changed slightly.
Things have changed, but yeah, I'm just saying that he did say, as a fallback, he did say that is one possibility if you really, yeah.
But again, it's more for
It's not,
evidentiary
yeah,
purposes.
it'd be more, yeah, get your resources together and file properly,
And relatively speaking, filing for copyright protection is really cheap
Yeah.
versus opening an LLC in California. I
Right.
think it's like $800 a year. So
Yeah.
a one-time $65 filing fee. And
Yeah.
again, throughout my career, I will be honest, I've maybe done 2 or 3 copyright submissions with the Copyright Office, like actually helping somebody file for copyright, because A, it's a relatively simple thing that people can do on their own, and B, that's usually like the last thing that you do when you have the final finished work product.
Right.
So sorry, go ahead.
Oh, I was just gonna say, going back to what you said a little bit ago, is that if something is in the news or public domain, that is a good question that I have about. So if something is, let's say, on a major news source, like a name brand news source that's mainstream media these days, that's considered mainstream media, are you allowed to take clips from mainstream media, or is it more the fact that the topic they're talking about is very widely available in public, in newspapers and in publications, so that the topic is what you could grab?
You're correct in both instances. I'll address the second one first. As it relates to facts and information are not copyrightably protectable. So like, JFK getting shot on November 22nd, 1963, like no one can own that. Like anyone can write about that specific thing, and they can write about their interpretations and where they were 9/11, October 7th in Israel or whatever. Those are factual things that occurred. You cannot own facts in that way. The first part of your question about taking mainstream clips, that again kind of goes into that fair use analysis. What are you using for? What are you using it for? What is the underlying purpose of it? If it's news to kind of generate news, that is to me leaning on more and more the side or factors of fair use. But again, it's always going to be a case by case determinative. The courts will decide on its own. But I will say, again, with times changing, the standards and practices change with it. One of my clients that I work with really closely is Watch Mojo on YouTube, and they're a pretty prolific top 10, YouTube channel where they count down the top 10 best clips from Friends or the top 10 best moments from Iron Man or whatever. And when my friend Ash started that channel in 2008, 2010, he would get takedown notices and threats of lawsuits every single day about repurposing people's content for his top 10 videos. And it was just through fighting off multiple lawsuits and asserting fair use and having many other people do this exact same thing that the industry has now kind of changed, and it's like, okay, well, we recognize that's probably fair use, where you're doing those limited like top 10 videos, or you're sharing information about Iron Man's best weapons. That will more likely than not fall into fair use.
Okay, so this is curious because this is something when you do it if you do a movie review and you run the movie trailer before you run it under the review,
Great example, because you got to remember, and this is actually super interesting. I was just reading Siskel and Ebert, the old movie reviewers. Remember them, right?
Oh, yeah.
I was reading their book, because when they came on the scene, there was no YouTube movie trailers and like the behind the scenes and the little clips of things in there. Like people didn't have access to that. You didn't get to go online and they call them EPKs now, electronic press kits. None of that existed. So if you wanted to see clips from the movies, you had to watch Siskel and Ebert, and it was really not until the invention of YouTube that all of these commenters and creators can now start stealing little bits and clips from the film. If it would have been 2012, you probably would have gotten a takedown lawsuit for that. In 2024, not so much. But even if you do get a takedown like notice on YouTube or something like that, if you truly believe that your content falls under fair use, and you've maybe discussed it with a lawyer, you can fight those takedown notices.
That's interesting. I have a friend who, he started a channel. He asked me to do some stuff on the channel as well. But basically, he talks about current news, like popular topics in the news, crazy stuff that people say that gets regurgitated over and over. And he'll take the clips, but he'll make most of the video about him talking about it, and then show like a 10, 15-second clip of it, be like, oh, this is why I think, this is a crazy statement, or this guy shouldn't have said this. And then, he goes into his analysis of it. And out of all the clips he's done, he's only got one challenge, and that was on a Joe Rogan clip that he used. But he disputed it for fair use, and he cited that he's making news content with it. He's not, his channel is not, he doesn't have monetization on. He's just doing, news content, and it's regurgitated all over YouTube anyway. And YouTube allowed him to dispute it, and he won the dispute, because I think it's one of those automated flags from companies where they have the hashtags on the media, and but
you raise a lot of really good, interesting points there. Some people are much more protective and pit bullish regarding their content. For my clients, when I see any of my clients stuff on YouTube, I'm gonna probably take it down because I'm just a little bullish when it comes to that. Other people, if it's not taking money out of their pocket, and it's overall supporting the fandom, or it's like, all the saying that all publicity is good publicity, right? Some people don't monitor and police their works the same way that Beyonce might, you know what I mean? So Joe Rogan probably has an extreme vested interest, especially because of his, well, I think his Spotify deal might be over, but when he did have the Spotify deal, they had an extreme vested interest to make sure that no Joe Rogan clips showed up on YouTube, because there's an exclusive deal for Spotify. So my job, context is everything. Going back to your friend, if he wasn't monetizing it, right, that's the first factor of fair use, is, are you making a buck off of somebody else's work? If you're not monetizing it, you're not making a buck. That's a check in favor of fair use. I'm trying to think of what else you said that he did. Oh, to the extent you are using somebody else's copyrighted work, what the court deems fair is you're only using the most minimal amount of the other people's work that you need to get your point across, and you are then adding your own commentary. So to the extent your friend is minimizing how much he's using of other people's clips and maximizing how much he's speaking, he's at least doing everything that he should be doing to try to stave off these potential claims and making his content for fair use.
Interesting. Okay.
Now, that isn't to say that all news clips constitute fair use. There's this very famous case that they teach us in law school, and I always got to bring this up because for Gen Z and Gen Alpha, they think the story is so weird. But do you remember those guys that used to get shot in the stomach with the bowling balls at the circus?
Yes.
Mm-hmm. I tell this story to my students all the time. They think that like I'm just the craziest person in the world. Yes, people used to get shot with a bowling ball.
Yeah.
And there's this very famous law school case, back in the 40s, 50s, or 60s or whatever, when a news program recorded a guy doing his act getting shot with a cannonball, and they put it on the news and tried to claim fair use, and the court said no, you stole the essence of this guy's work, you owe him. So there's always fun little cases like that stick in the back of your mind that they teach you in law school, that try to set the buoys or the boundaries of what is fair use and stuff like that.
Interesting. That's an interesting case, because I mean, if people, especially back then, if you're going to a show, you want to be excited. You don't want to know everything beforehand. And what this channel evidently did was show this guy's routine, and it devalued the fact of maybe some people might not want to go now because they could see it.
No, I've seen it.
You're thinking just like the court, man. You're thinking just like the court. You've stolen the guy's way to make a buck. It's not fair.
Yep.
You know, a case in point, I don't know if anything ever came of it, but you know, there was a documentary about Russell Brand that was exclusively streamed in the UK on Channel 4. It is geo-blocked here in the United States. But when I wanted to watch it, I could find people doing reactionary content to that video, and it's just I got to watch the whole video for free.
Yeah, yeah.
So
Interesting.
the Channel 4, if you're listening, that's
So also, because a lot of people that watch this channel are involved in the comic book industry, and a lot of them are comic creators. So another thing that comes up in their community that I hear a lot from creators that I'm friends with is, hey, I'm working for Marvel, DC, Image, or whatever it might be. Well, Image not so much anymore because they allow creator content. But like, you know, let's say a major studio, and hey, I designed this brand new character, but I forgot to retain the rights to the character. So how would someone in that industry be able to retain the rights to a character they create while they're under contract for another publisher?
You're never going to. When you're hired in those kind of roles for corporations like that, you're hired solely as a grunt work for hire. All creative ideas that you can contribute, come up with, and give to the company, those are solely owned by the company. So for those potential creators, authors, artists, or whatever, what I tell them is like, you know, there's a difference between having a good idea that you're like, oh, like, that's a good idea, maybe we can make a buck off of it, and like, this is my baby, this is what I've spent my whole life, you know, wrapping my head around developing these characters. And if you look at somebody like you know, like Rick Kirkman or Todd McFarlane, or who's the guy, Mark Mason, who did Jupiter's Land, what was the Jupiter's one? Mark Mason, he's a pretty prolific comic book guy, right?
Yeah, I can't remember the
I can't remember all of his comic book series, but guys like that, you know, they're commissioned all the time to write for X-Men and Marvel and DC and whatever, and you know, they don't own any creative contributions to those works. They have to establish their own world, their own characters, and find a way to, you know, either independently finance and build steam around those things. I think that's kind of what Todd McFarlane did, right? And same thing with, is it Richard Kirkman? Robert Kirkman? Richard Kirkman?
Robert Kirkman's that's the
Walking Dead and Invincible.
Walking Dead, yeah.
Yeah, you know, you're never gonna, I mean, unless you're already somebody who's established, you're never gonna walk up to one of those companies and be like, hey, do you want to share characters in this universe? And or I don't think that, you know, Marvel's really in the business of like buying other IP and trying to integrate it into the Marvel universe, right? They're going to wholly create new characters from the ground up. But you know, I've heard stories on both sides of, you know, people who've created like the Winter Soldier, the Bucky Barnes iteration, right? Like those guys maybe didn't make any money. I don't know that they made a lot of money off of the Winter Soldier, but they still were invited and involved in a lot of the aspects of that film, and I'm sure they got to walk the red carpet or something to that effect. So I mean, you know, consolation prize or whatever, but it's really if you guys, you know, remember your history, Marvel was a pretty bankrupt company up until 2008 when they took a mean Robert Downey Jr. off the streets and blew him up into Iron Man. They were not in a position where they were, you know, super mainstream until they got financing, and then they got, you know, plus integrated themselves into the Disney universe, which distributes them to all corners of the globe.
Yeah.
So a long way of saying you can't own your characters. Keep your best kept secrets to yourself and develop them independently on your own.
Yep.
And I truly believe.
And I will say, real quick, I will say, I don't remember exactly who it is, but there is an exception to the rule where they went back later and they got rights. But this is somebody who was involved from like the 1940s forward. So, you know.
Right. And so, they didn't know back then. You know what I mean? Like, I'll tell you a secret. I've actually had the physical Sony Marvel Spider-Man deal in my hand. I've had the physical Fox Marvel deal in my hand. And if you're going back and looking at those contracts were written in the 90s.
Yeah.
They cannot even begin to contemplate all of the different means of exploitation that we have now, and how the shared universes and cross medias and platforms, contracts have become wildly more sophisticated from those days.
And even over the last few years, we've seen that changing on the fly.
Yeah,
the whole streaming release of movies with what's her name, Scarlett Johansson. That kicked up a whole nother storm.
It changes all the time. One of the things that I heard, and I have no insider information, this is all completely speculative. This isn't in baseball information. One of the things that I heard rumored was that they couldn't recast Jonathan Majors as Kang because he had it maybe contractually obligated or guaranteed that they couldn't recast him after the whole Don Cheadle, Terrence Howard thing. Yeah. So, we as entertainment attorneys were very reactionary. We hear these stories, and then all of a sudden we start negotiating and building deals and structures around to protect against these things. So again, I don't know if that's true at all. It's just mere speculation, but it could be.
It makes sense that it could be. Absolutely. Yeah.
Yeah. It makes sense to me. And if I were Jonathan Majors' attorney, that's something that I would have probably asked for. I don't know if Marvel would have given it to me, but
by the way, I want our viewers to notice the chair you're sitting in, that you are a fan, and you told us before we started that you have all kinds of comic book and collective stuff around you.
I got all my Marvel action figures, all my SH Figuarts and MCU Marvel. Probably the biggest highlights of my career so far have been I got to walk the Thor: The Dark World red carpet premiere. Not the best Marvel movie by any means, but really cool to watch. I think I sat behind Liam Hemsworth the whole time, which was kind of cool.
Were you able to see the movie, or did you have to duck around and kind of?
No, it was Liam. It was the shorter one.
That's right.
Chris was in the main theater, and they kicked all the losers and the brother and the employees to the smaller theater. But I got to do that. I got to work on Vin Diesel and Bradley Cooper's voiceover agreements for Guardians of the Galaxy 1. Going back even further in time, I got to work on the original Avengers Earth Mightiest animated series that Film Roman did prior to the acquisition of Marvel by Disney. So yeah, I'm a pretty big fan. This was, like I said, always part of the plan that I would come to Hollywood and get to play in this toy box with these characters and these people. It was interesting, and I always find this funny. I'm listening to the history of the MCU book right now, and they say something in there like 2008. Bob Iger didn't know who Marvel was, so he had to pick up a coffee table book encyclopedia and educate himself on that. And I just have flashbacks to growing up as a kid and being told by parents and adults comic books are stupid, you're wasting your life on this stuff. Why are you learning about all this? And I'm like, well,
yeah. Very cool.
So that leads me to the next topic that I wanted to talk about is we have two things here, and I'm sure it falls under copyright extremely much, is that we have people that will take an image, a copyrighted image, let's say, for example, NFL icon, and they'll take away one tooth and change the eyebrow and be like, oh, well, now it's copyright free. It's not trademarked. That's one thing I want to bring up. And then the other thing is AI, man. AI has been taking copyright characters into insane worlds that are probably not designed for them by the companies that own the copyrights. So just want to get your take on those.
Yeah, with the AI of it all, I'll start there. We're really going to need legislation, government oversight, government intervention, or government protection for these kind of things, because just the capitalistic nature of our society is never going to let people say oh, we're going to protect you from signing away all of your rights to AI. We just live in too much of a capitalist society where if Facebook or Instagram or YouTube say, hey, sign these standard terms and conditions, no court in the world is going to say you didn't voluntarily give up your rights to these things by agreeing to be on Instagram or Facebook. So we need some form of government intervention into it from that perspective. But, AI, at least as it is right now, is so limited in terms of like actually coming up with originality. It does really good jobs of like just coming up with macro concepts, but really getting into the details of originality, it can't do that yet. And you know, I use AI for entertainment contract drafting. So when I'm doing my negotiations and stuff like that, I have specialty software that is AI and it's entertainment and contracts and stuff. But like that could never replace me as a lawyer. I akin it to being a race car driver. Like Joe Schmo off the street isn't going to be able to get into a Formula One race car and get, you know, do really cool things with it. You have to have a trained pro get behind the wheel first, and then they use that equipment. So that's kind of my feelings about AI. You know, it will change and evolve, as with the law as well. It's a scary existential crisis for the entertainment industry, to be sure. Yeah, sorry, not to get too heavy.
And then the other question was the fact that, you know, there's people out there that make these T-shirts online, or they'll take logos and they'll adjust things. Like they'll be like, oh, I took away a tooth on an alligator and the eyebrow on the, let's say, the Florida Gators trademark logo, and they're like, oh, now it's trademark free.
Again, it goes back to what I was saying with people not really understanding what fair use is, and or not really understanding what transformative use or transformation of copyrighted content is. You know, copyright protection only protects originality. So to the extent that you're, you know, maybe adding an eye patch and bucking the tooth of somebody, that's not entirely creative, and you're not creating a wholly new original transformative work on that, unless you're, you know, trying to say, you know, something politically about pirates and, you know, whatever. Like again going back to fair use and criticism and stuff. But there's just not enough copyright police in the world to monitor and stop and sue everybody.
Interesting. Okay. I mean, that's some good points there. And, you know, I know we briefly talked about it before the interview today, and I kind of want to get your opinion on the Yuzu emulator situation with emulation, and kind of like in general. If you look at the Yuzu thing, I'll just restate the facts again. Was in Nintendo's lawsuit, they accused Yuzu of making money off the product because they had a Patreon. They accused Yuzu of distributing pirated content because they had links to where they could download Nintendo's IPs and softwares. And then the third biggest kicker in that was that Nintendo said that, you know, the Yuzu emulator was more than just emulation, because it gave instructions on how to put decryption keys in there and how to rip your own decryption keys to decrypt their games, and you could run them on a PC. And I want to get your take on that.
Yeah, you know, the three instances that you cite that Nintendo is referencing as being like the most damning, that is more or less like the evidentiary facts towards the copyright infringement claim. They're claiming copyright infringement, and they're supporting it with those three, you know, instances that you've given me. It's an open and shut case. They committed copyright infringement. Could they maybe try to argue an instance of fair use because they weren't monetizing it? Maybe, but again, they're cutting out the bottom line of Nintendo and their ability to sell more and more copies. No court in the world is going to deem this to be fair use. So it's an unfortunate thing, but you know, it's pretty open and shut, black and white from a legal perspective. Now, from a consumer perspective, from a corporate transparency perspective and optics, you know, it's never great when companies sue their fans for trying to enhance their fandom, or, you know what I mean? Like, I'm a big time Pokemon fan. I've played Pokemon emulators where they're like, you know, play as Team Rocket, or like, you know, be Giovanni, or run your own gym and stuff like that. So, you know, it never looks great when you're suing your own fans. And sometimes, you know, I'll bring this up because it came up in the news recently. A country music star, their legal team was suing and shut down a illegal merchandise page that made T-shirts and hats and whatever on this country singer. and his legal team was suing this Ma and Pa merchandise manufacturer. But the country singer found out about it, and he's like, you know what? Like, I don't want to sue my fans. I don't want to like create this bad blood. So they dropped the lawsuit. Now, does it mean that they didn't break the law? No, they absolutely still did. It's just don't want to sue your fans.
Yeah.
But I'll tell you, the really interesting case with Nintendo is the Nintendo Pokemon, the Pokemon knockoff case. What were those things called again?
Which one's
the new one that just came out?
Oh, Pal World. Yeah,
Pal
Nintendo
World.
hasn't
Yeah.
officially done anything yet, but they're watching closely. They said.
That one's a real interesting one because that you know, we're talking about black and white. You know, the emulator thing, that's black and white. That's open and shut. That's copyright infringement for sure. The Pokemon Pal World thing, that is all sorts of murky gray area that us lawyers love to dig in and make arguments about why it isn't or is infringement or fair use. So the fact that the Nintendo and Pokemon haven't brought lawsuits yet means that it is a very interesting legal question.
Yeah, it's like a situation with Power World is that some people online that claim to be developers, and we don't know if they truly are, but they're just online claiming to be developers. They claim that the body similarity is so close, if you take it down to graphs, that it's almost like a Pokemon. But then you have the creators of Power World that are like, no, this is not the same exact graphs. There's different color schemes, and they may have similarities, but they have guns and ammo, and they're doing crazy things, and they're not called the same thing, and we developed our own world, you know.
This is where lawsuits, this is where we have fun. This is where the real true lawsuits occur. I'll give you a good example that I think might help articulate and illustrate this. There was a Pixar movie called Onward that came out with Tom Holland and Chris Pratt as the main characters, and they go on this little Dungeon and Dragon style side quest or whatever, and they have this 80s rocker van that they're rolling in the whole movie. It's this purple and pink neon van with a unicorn on the side, and it's got, you know, rock and roll symbols and whatnot. And, you know, it's just like, to me or you, to anyone on the street, it would just look like a generic 80s rocker van, and you know, don't think anything of it. This woman, this tattoo artist, brought a lawsuit against Disney because she had a van that looked almost identical / substantially similar to the van that was in the Pixar. Now, absent any more facts than that, you can assume, like, people have independent ideas all the time. Armageddon and Deep Impact, essentially the same movie, not necessarily ripping each other off if two people have separate ideas on separate sides of the world, right? So the court will look at the what they call the amount of access that the parties had to one another. And if they didn't have any access to one another, then there's probably not any copyright infringement between the two. However, in this case, it was shown that Pixar actually rented this van multiple times for Pixar retreats for their people, and they actually had rental agreements for this van. So it wasn't just two people on two separate sides of the country had the same idea for the same retro 80s looking van. You know, the substantial access that Disney and Pixar had to the van, the court assumes because of substantial similarity and great access that's just infringement.
That's interesting. I'm curious, did the lawsuit play out yet, or is it still going?
No, because these are the ones that all settle because no one wants to go to court because you don't know how these are going to turn out.
Oh, so the person with the van probably got a nice little thing, never to talk about it again.
I'm sure they got a nice chunk of money.
Yeah, probably still running out that van, hanging out too.
Another great one is Ed Helms on The Hangover 2. He got the Mike Tyson tattoo on the side of his face. Mike Tyson doesn't own the copyright to that tattoo. The tattoo artist does. So he ended up suing, you know, I think it was Warner Brothers, and that image of the Mike Tyson tattoo that was used in all of the marketing and promotion of Hangover 2. It was everywhere.
So that is really interesting. So a tattoo artist can claim copyright on a design that they designed and inked on somebody?
Yep.
Yeah.
I did not know that.
Again, the second your pen touches paper, the second your brush hits canvas, the second your needle hits skin, if you're creating an original work of authorship, absent a written work for hire contract, you are the owner of that image.
Wow.
So this comes up a lot when you're getting your school photos taken, especially like senior photos, right? Oftentimes the photographer will put a gross water stamp on it, and like they're only going to give you access to some of the photos because they're maintaining that they own the copyright to those photos. Whenever I hire a photographer, like I hire a photographer for my wedding or a videographer for special events, I make sure that there's an agreement in place stating that I'm hiring you. I own the copyright, not you. Most people don't roll up to a tattoo shop being like, hey, sign my contract saying if you draw this for me, I own it.
Oh, that's interesting. So any tattoo artists out there listening, or people getting tattoos and you like your tattoos and you want to take lots of pictures of them, maybe you want to own it.
Yeah, I mean, if you're coming up with your original design, and I would imagine that 9 out of 10 tattoo artists already have something like that in their contract that you're signing when you go in and you sign up and do the thing, right? Like if you go to the doctor's office, if you look at the fine print, there's going to be language in there that they have the right to video record you for medical examination purposes, and they can show your bodies to kids. And I don't know, you always got to read the fine print.
Wow. That just gives me a lot to think about because I'm always curious about copyright law. One other thing I want to bring up with you real quick is that, so voice actors. Yes. Voice actors have a special talent. They're very unique in the fact that they train their voices to be certain characters for corporations. But now we see that in some aspects, corporations are like, well, we've invested millions into AI and we own the character that you voiced. So we want to train our AI with that voice. And, there's a backlash with voice actors that say, well, wait a minute, that's my voice. You can't take my voice and then train it to be future characters.
So, you're raising something that I just spent the last 2 weeks pulling my hair out over because I was actually casting voiceover actors for an adult animated series, and I had to address this issue with every single one of the agent managers and attorneys for the voiceover actors that we were hiring. But, you kind of said it at the outset, the company is taking the position that they own those characters. Hanna-Barbera owns Fred Flintstone. Warner Brothers owns Bugs Bunny. Fox Disney owns Bart Simpson. So to the extent that they own those characters, Nancy Cartwright could die tomorrow. They got to make a new Bart Simpson by virtue of the fact that Bart Simpson sounds like Nancy Cartwright. They're going to find someone who sounds like Nancy Cartwright to continue on playing Bart Simpson. And in a lot of instances, if you're going back and looking at, video games or commercials or theme park rides or anything like that, they may not have gotten the original voiceover actor to do those dubs. And it is something that was and it still is very common. And the SAG protects from that to the extent that there are like reuse fees. There's protections on certain rights of dubbing, and then there's contractual protections that your agent can and manager and lawyer can negotiate for you to get the first right of opportunity to dub. But at the end of the day, if the studio wanted to re-record Fred Flintstone's voice, Fred Flintstone voice actor never got a say in that. So now we fast forward to where we are today, and it's like they have better technology to make someone sound like somebody else. The theory behind it hasn't changed. They can still bring in whomever to sound like Bart Simpson. Now they just have a better tool to make Bart Simpson sound more like Nancy Cartwright. So, again, I go back to if it's precious to you and you don't want to give it up, keep it locked up in a bottle. But if you're being paid for your voiceover acting services to create characters, those are creative work for hires in our industry.
Okay. So I assume then eventually, if companies, I'll throw out an example. They're not saying they're doing this, but let's just throw out an example. IDW and Marvel. If
Mhm.
their artist draws this really cool, unique, Incredible Hulk and done it for, let's say, 15 years, and that person goes on to retire or unfortunately passes away, at their behest, they could essentially train an AI system with all the images of that Hulk and just reuse it in their own AI system if they wanted
Yeah.
to. And there's nothing stopping them from doing that.
Yeah. No, I mean it's a scary. I don't know that I have a good answer because I think you're right. You're now replacing humans
Yeah.
in their work. So there has to be some protection. I don't know where it comes from because again, from the capitalist side of things, corporations were paying you a lot of money to own these rights.
Yeah.
Mm-hmm.
Well, it's like, like the voice of Optimus Prime retired last year. He's done. He's 81 years old.
Yeah,
But
Kevin
but,
Conroy.
but Kevin Conroy, and Kevin,
Peter Cullen.
Peter Cullen for Optimus Prime. Kevin Conroy passed away, so we'll never get any more Kevin Conroy. But you can't have somebody else come in with a squeaky little voice and be Optimus Prime. You're going to have somebody that's pretty close to what Peter Cullen sounded like, or people are going to go, "What's that?" You know.
Everyone
So,
has their own iteration of Batman's
yeah,
voice, but if you
right.
notice, since Christian Bale came out, they almost all sound
Yeah.
exactly Christian Bale's version of Batman. They don't sound like Adam West's version anymore.
No, thankfully, yeah.
It's a very, very complicated issue.
Yeah.
You know, to what extent is Carrie Fisher and Princess Leia, like, to what extent are they the same person? Princess
Yeah.
Leia is always going to look like Carrie Fisher, and she's always going to sound like Carrie Fisher.
Yep.
Yeah, that's a good point. And now we see.
It's funny for me because some people are like, nobody else could ever play this actor. They can't replace him. I'm like, well, the thing with using humans as actors is you really don't have a choice. They age out, or something happens. Nobody else could be Iron Man because because what's his name is Iron Man now. I'm like, well, if you're gonna keep making those movies, somebody's gonna have to step into those shoes. So
And the thing is, though, is like we will need protections for the common man
yeah,
on AI and those things. In no universe is the estate of Robert Downey Jr. going to let people freely monetize a AI version of RDJ for money. What they're going to do is that they're going to create a digitized version of Robert Downey Jr. and sell those rights to the highest studio bidder for a licensed term period of time, and then they'll expire and they'll go to a different studio. Like I guarantee you, my kids will be watching Arnold Schwarzenegger movies, well after I'm gone.
Yeah, true.
Nothing wrong with that.
And
there is, but there isn't. Who's the next Arnold Schwarzenegger? You know what I mean? Where's the next one? Who's the next Jennifer Lopez? Who's the next one in line for these things? If these, I don't
know. Well, the last question I have for you on this episode is something that is very prevalent in the gaming community, something I've always said, but people disagree with me, is that people think when they buy a video game, when they buy the video game itself, the physical cartridge or disc, that they own the video game. And if you ever look on the discs or the cartridge, it says licensed for home use only. So I always tell people when you're buying a disc or you're buying a cartridge, you're only buying a perpetual license to play that game. You're not actually owning the media the game is on.
So there's a lot of nuance to that, because prior to the whole digitizing of games and actually giving out a license code, and like what we do now where you're buying a license to a Prime Video on Amazon Prime, those are a very different type of license than the license that you would get when you're otherwise buying a record, right? You don't own stock into Marvin Gaye when you buy a Marvin Gaye record, but you physically own that copy. And under what is known as the resale doctrine, you can sell it on eBay for resale. You can sell it on, Amazon resale, go to a record store, whatever. So ownership rights do pass to the physical material stuff. Like, I own this Thor action figure. I don't own Thor character or Thor look, but someone can't take this from me and say it's mine. I only gave you a license to play with it. That is very different from buying a video game through a Netflix, through an Amazon, where you are only getting a limited permission to play with the character until the company decides they want to terminate. So there's some slight nuance. There's like 3 levels to that.
So what about the people that still buy physical media of video games?
You own that physical copy. It's not like Microsoft can come in and say, hey, your license to use is expired. We're going to take this physical copy out of your hand. If you buy the digital version, they can.
Interesting.
What's interesting is, on most of those physical copies, especially the games not actually on the disc. It's actually just a thing that allows you to download
they started doing that
version.
this generation, yeah. Because
we're in the renter's economy.
But basically.
That's what it is. They're trying to take it to a place where if they say, hey, we no longer want you to use or play this thing, they have the ultimate right to do that. Disney has announced very recently that they're pretty much done doing physical media sales. They stopped all physical media sales in Australia, and like moving ahead after 2026 or 2027 or something like that, they're not going to be printing physical media. To me, as a cinephile, as a lover of art, that is extremely dangerous, because someday they could decide that Disney is not PC anymore and they want to get rid of it. I don't like that. So
No.
I buy physical media still because I want to, like, I own, the first 12 seasons of The Simpsons, because I don't want anyone to touch that. That's mine.
Right. Plus it's been proven that like on Disney, on their streaming service, the versions of the movies you see there are different than the versions you might have on your disc at home.
They can edit them. They can change
They're
them.
editing content. Yeah.
Well, like Funimation, Sony owns Funimation and Crunchyroll, and recently they decided to get rid of Funimation, and everybody had their purchase stuff on there, and they're like, "What's gonna happen?" Somebody's like, "Sorry, it's gone."
Well, but that's what I'm saying. You didn't purchase it because you didn't purchase physical assets. You purchased the digital license. Now, the difference between them in the legal sense is subtle and nuanced, but in the practical sense, there's a big difference between a digital license and a physical copy.
Interesting. That's some good points there. Okay, and I promise this is the last question I have now.
Oh, you're good, guys. I love talking.
All right.
Fun.
So you have the physical, let's say, Simpsons set, right? Somebody has a physical Simpsons set. Now, some countries don't really abide by DMCA or have the same copyright laws that we do, or they just don't acknowledge it, even though they're supposed to. Yeah, they don't care. So in a lot of those countries, people make backups of their media, right? Mm-hmm. Now in America, it's been questioned before, and I don't know what the latest court ruling is, but I know sometimes courts might say, oh, it's okay to have one backup of your media in case something happens to your media. Then there's other courts that are like, no, you can't. That has protections. You can't make backups of that.
It goes to exactly what we've been saying kind of this whole time about fair use and deciding it on a case-by-case basis. I don't know that I've ever heard those cases that you're particularly referencing, but like in most circumstances, you're not going to get caught, monitored, or policed for making backups until you start selling those backups on the open market. And once you start selling those backups, you're now violating the first tenet of fair use, as well as putting a target on your back. So the people who, I'll be honest, I took my 500 DVD library when I moved to LA. I decided I'm never going to move that across the country again, and I digitized all of it. Is that copyright infringement? Yes. Is it fair use? I don't know. It would take a lawsuit to determine that, but no one's going to probably sue me unless I'm somehow monetizing that library.
Yeah, you're not selling copies of everything that you.
I'm not selling it. It's for when the world ends and I still have a backup generator,
right?
And don't have internet, I can still watch some episodes of The Simpsons. And
the term we used to use doing that was called an archival backup, and usually they're stored away from the originals. Basically, is the way we.
I have two. I have one at home, and I mailed one to my brother.
There you go.
I had a 500 DVD collection that I had spent my whole life building, and I didn't lose any of it.
Sadly, I used to. I lost all of it, but that's a whole nother.
I can't say that I've sat down and watched it in 10 years, but it's there if I need it.
But if you're like me, you've watched everything you owned at least once. You know.
I'll tell you what, though, there are, this is something that kind of comes up more and more frequently. Going back to the physical side of media of things, there are movies that are no longer in physical print that you are
Right.
not able to find digitally. And it could be that there's a rights issue holding up the particular project. I'm looking at you, Dogma. Dogma, Kevin
Yeah.
Smith's Dogma, one of my favorite movies. But if you want to watch it, you have to buy like a $40 DVD
Yeah.
because there
You
are no
can't find.
Blu-rays.
Yeah. You can't find it. Yeah.
You can't stream it because Harvey Weinstein owns the rights and he's sitting in jail and he's not going to give them it.
Yeah.
Or the one that I'm very interested in going and watching because I haven't seen it yet. There's this hidden gem of a film called Basketball Diaries with Mark Wahlberg and Leonardo DiCaprio.
Great movie. Great movie.
Yeah, but you can't find it or stream it anywhere. And you know why?
No.
Paul, you've seen the movie, so maybe you know why. But apparently, there's a very famous scene. It's a dream sequence scene where Leonardo DiCaprio shows up to the school in all black leather and shoots up the place.
Yeah.
Oh. Yeah.
Yep. Yeah.
I don't.
So Marky Mark and Leo are gonna want that buried for all time. You know what I mean? So sometimes getting your hands on those physical media, it is a way to preserve things that could be lost forever.
It's like not quite the same level, but when Spider-Man first came out, it was pre-2001, and one of the coming attractions was him capturing a helicopter between the twin towers, and you can't find that footage anywhere. They wiped it from the earth. It's nowhere to be found.
I'll tell you, I have a hard time finding sometimes older commercials that I know exist, but that are there's a commercial in particular that I always try to find, an old Hardee's commercial at Paris Hilton that I'm convinced that her team has just scrubbed off the internet.
That's why I'm thankful for the sites that do manage to find the old videotapes where they happen to capture a lot of the old commercials and stuff. So they pull them and they save them, and you can find them if you search for them. Not necessarily that one, but that's the only way you can find a lot of the old stuff from when I was growing up, because I predate VCRs. Okay, we're talking,
I miss commercials, and I'm weirdly in the category of people that are glad that they're coming back.
Well, and some of them are just fun too. And if you ever watch Carol Burnett and Friends, some of the best bits they did was making fun of those modern day commercials back in the 70s and the 80s, because they were just wacky. They were just,
We don't even get fun Super Bowl commercials anymore because it's
not
too
really
expensive to do a long, fun commercial. I mean, Super Bowl commercials, the Audi Super Bowl commercial every year was the highlight of the Super Bowl. And I don't think I saw one last year.
And the Budweiser horses.
Budweiser horses. They don't even
and the E-Trade monkey, the E-Trade babies, that only show up for the Super Bowl.
Wow. Yeah. I haven't seen that in a while.
But they don't even do full movie trailers anymore. No. They just tell you, go find the full trailer online.
Yeah. Here's a little clip now. Go to this site, go look at it. Oh, thank you. Yeah.
Bunch of cheap asses. Well, thank you guys. This has truly been a pleasure.
Thank you. I do have one more question we ask everybody we interview. Yeah. Pepperoni and pizza, yes or no? And you're
pepperoni
or pineapple on pizza.
Wow, Paul, slacking.
No? I'm tired.
I'll be honest. I love pineapple. I love a hot honey pepperoni and pineapple pizza. There's this place in Santa Monica called Emery Squared. They make the best Detroit style pizza, and they have one of the best hot pepperoni and pineapple pizza. So
I might try that once. I just once, because you said it's hot, so it's got some bite to it. And I
love hot honey. Hot honey is my new favorite invention. I put it on everything.
Oh wow, that's interesting. Okay, yeah, I never heard of hot honey, but now I'm gonna go look for it. I know
it's on every major pizza now. It's very trendy.
Is it? Oh,
in California, you guys, I grew up in California. They'll put anything on pizza at one point or another.
Yeah. That's interesting. I'll have to check that out. But Joshua, where can people find you online or what you're up to?
Yeah, I'm pretty easy to find online. You can find me on my Instagram at Lastine Law, just my last name, Lastine, Lastine Law. You can find us on our website, LastineEntertainmentLaw.com. find me on LinkedIn. Shoot me a smoke signal, a page, my beeper. No, I'm just kidding.
That's right. He's got a beeper from the 80s still. Yeah.
Awesome. Well, thank you so much for hanging out with us and teaching us about different copyright laws and your opinions. And, it's great. I'm going to have to go back and listen to this again because there's just so much good information in this episode that you gave and an insight to. So thank you.
Well, Carlo, thank you for having me. Paul, thank you for having me. Audience, thank you for having me. Hope you're back soon.
Thank you.